districts came up, and I know that in our work group sessions, that was also a common theme.
Bye-bye, Bernie.
Hey, thank you. That's a compliment.
Why reach the point where
No problem.
can ask our executive
No problem. I work to help you guys, okay?
on the radar of the commission in terms of looking at whether there have been, about that before, whether we can gather any available complaints or data, or have a discussion with the Inspector General about that to put it on a future agenda, or perhaps to get more testimony during the town halls. But again, it's something that we've heard about now again and again, and I think that's one of the charges of this commission, to try to identify systemic issues, and it appears to me and Commissioner Harris that it is beginning to rise to that level of a systemic issue. The second point I'd like to make is that as one of the public members testified today, we did have a young woman last meeting who testified about her mother, Claudia, and I think we owe it to her and to her mother to really look into this and to try to have a short report or a presentation back from Mr. Williams or the staff about what, if anything, we can determine happened, and to the extent that she came to our body and testified, and now is in immigration detention, I think is outrageous. If there's any connection that we can determine, to determine that. So that would be my request, that to the extent that we can, find out some further facts and report back to this commission. That would be my request.
All right, we'll accept that request. The executive director will take a look at both of those issues. Now we're going to call upon Captain Scott Gage and Captain Woolham to make what I believe are a two-part presentation to the commission. Just by way of background, one of the goals of the commission is to make an assessment of use of force by the Sheriff's Department and its patrol function, both understanding the policies, the training, the investigations with regard to out-of-policy use of force, and the discipline system and how it's working with respect to situations where there is an out-of-policy use of force. So we're going to explore that topic over a series of presentations, but we're starting with presentations from the Sheriff's Department with respect to what the use of force policies are, also what the training is for deputies with respect to use of force policy, and we're also going to get into, I believe, the internal affairs function, including the staffing of internal affairs. So this is a very important presentation. And Captain Gage.
Good morning, Commission. Thank you for having me here this morning. Give a brief presentation of some of our force policy and some of the training related to that. Before turning it over to Captain Woolham, who will cover the investigative component and some of the internal affairs rules in that. I'm the captain of the Sheriff's Department Training Bureau. Before I give you the presentation, kind of let you know what our responsibilities are. We cover the academy. We cover advanced officer training. We do vehicle training. We do weapons training. We do force training. We do crisis intervention training, civilian training, and we also have the video production. Custody division, court services division, and some of the more specialized units, such as our SWAT teams and more of the elite detective units, have their own training component, so they can train their people in specialties. Is mic on? Sure.
Is it on? Can you just have it?
Well, again, it's very simple how the department defines force. Force is defined as any physical effort used to control or restrain another or to overcome the resistance of another. As I go through the policy, this is not the entire Sheriff's Department force policy. There's over 30 different sections to that. I chose a section that I think will give you a broad understanding of our department policy. Authorized use of force. Department members are authorized to use only that amount of force that is objectively reasonable to perform their duties. Objectively reasonable means that department members shall evaluate each situation requiring the use of force in light of known circumstances, including but not limited to the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the member or others, and whether the suspect is actively resisting, and determining the necessity of force and the appropriate level of force. Department members maintain the right of self-defense and have a duty to protect the lives of others. The term objectively reasonable will be something you'll hear throughout this presentation. Unreasonable force. Department members shall use only the force which is objectively reasonable. Unreasonable force is that force that is unnecessary or excessive, given the totality of the circumstances presented to the department members involved in using force. Unreasonable force is prohibited. The use of unreasonable force will subject department members to discipline and/or prosecution. The force policy and the training, especially the training related to force policy, is kind of a living organism. It changes. It changes as laws change. It changes as case law is reviewed at the appellate level and Supreme Court level. So we are constantly reviewing our force training and policies to make sure we are meeting the standards of the state as well as the country. Continuing with unreasonable force, we do have specific things that we do preclude our deputies from using unless it would justify deadly force. Those are head strikes with an impact weapon being a baton, flashlight, anything other than a personal weapon of any point. Deliberately or recklessly striking an individual's head against a hard fixed object, roadway, driveway, concrete floor, wall, jail bars, etc. From a standing position, kicking an individual in the head with a shod foot while the individual is lying on the ground floor, and/or kneeing an individual in the head deliberately or recklessly causing their head to strike the ground, floor, or other hard fixed object. This slide should look somewhat familiar if you were following the news about 5 or 6 weeks ago, as the Los Angeles Police Department added a de-escalation policy to their policy. This has been in our policy for several years. Force prevention principles. Department members shall only use that level of force which is objectively reasonable, and force should be used as a last resort. Department members should endeavor to de-escalate confrontation through tactical communications, warnings, and other common sense methods, preventing the need to use force whenever reasonably possible. When force must be used, deputies and staff shall endeavor to use restraint techniques when possible, and only use that level of force necessary for the situation. Our force policy was built on 3 different things: California state law, federal law, and case law. (835A) California Penal Code. Any peace officer who has reasonable cause to believe the person to be arrested has committed a public offense may use reasonable force to effect the arrest, prevent the escape, or overcome the resistance. It's based on the United States Constitution. The Fourth Amendment recognizes the right to remain free from unreasonable search and seizure. This is what established the objectively reasonable standard of care. Graham versus Condor. It's a 1989 United States Supreme Court decision. The components to determine reasonableness. It's taken from the perspective of a reasonable officer, examined through the eyes of an officer on scene when the force was applied without hindsight or 20/20 vision, based on the circumstances confronting the officer without regard to the officer's intent, based on the knowledge the officer acted properly under the law. Continuing with Graham versus Connor. Not every push or shove, even if it may later seem unnecessary in a piece of a judge's chambers, violates the Fourth Amendment. The calculus of reasonableness must embody the allowance for the fact that the officers are forced to make split-second judgment in circumstances that are tense, uncertain, and rapidly evolving about the amount of force necessary in a particular situation. Move on to our deadly force policy. Department's policy on use of firearms and deadly force is: discharging a firearm at another human being is an application of deadly force and must therefore be objectively reasonable. Each department member discharging a firearm must establish independent reasoning for using deadly force. This is stating that just because my partner fires, that is not enough for me to discharge my firearm. I have to identify the deadly threat myself, independently of what my partner's doing. The fact that other law enforcement personnel discharging their firearms is not by itself sufficient to justify the decision by a department member to shoot. Department members may use deadly force in self-defense or in the defense of others. only when they reasonably believe that death or serious physical injury is about to be inflicted upon themselves or others. Continue with the deadly force. Department members may use deadly force to effect the arrest or prevent the escape of a fleeing felon only when they have probable cause to believe that the suspect represents a significant threat of death or serious physical injury to the member or other person. If feasible, members shall identify themselves and state their intention to shoot before they shoot fleeing felon. This came out of a 1985 Supreme Court case, Tennessee Gardner. We can't shoot a felon just because they're running from us. We don't do that. The law is very clear on that. No training.
Bullshit.
Use firearms against vehicles and/or occupants of vehicles. Firearms shall not be discharged at a stationary or moving vehicle, the occupants of the vehicle, or the tires of the vehicle, unless a person in that vehicle is imminently threatening department members or another person present with deadly force by means other than the moving vehicle. The moving vehicle itself shall not presumptively constitute a threat that justifies the use of deadly force. Department members shall not move into, remain, or otherwise position themselves in the path of a vehicle in an effort to detain or apprehend the occupant. A department member in the path of a moving vehicle shall immediately attempt to move to a position of safety rather than discharging a firearm at the vehicle or any of the occupants. Basically, we're precluded from shooting at a car unless somebody in that car is using some other weapon than that. We do leave a little bit of room for very specific and rare cases. The very bottom line, the policy may not cover every situation that will arise. Any deviation from the provision of this policy shall be reviewed on a case-by-case basis. Simplest example to provide would probably what happened in East France not too long ago, where that vehicle was plowing through a crowd of people. In that case, I think everybody in this room would say it would be reasonable for an officer to discharge his firearm at that vehicle to stop that threat. General provisions related to deputy-involved shootings. Immediate action shall be taken to care for the injured, to apprehend suspects, and to protect the scene. Assisting personnel should attempt to locate and identify any witnesses to an incident. Supervisor's responsibility. The first supervisor at the scene shall ensure that the injured have been cared for, suspects have been apprehended, and the scene has been protected. The first supervisor at the scene shall ensure all civilian witnesses have been identified and shall attempt to have all witnesses except for immediate family members transported to a station to be interviewed by homicide investigators. We teach and we train and we have policy that we have a duty to care for anybody. We use force, not necessarily even deadly force. We use force on the suspect. We have a duty to care.
Question.
Yes, ma'am.
Could you explain what shall means in this case?
Shall means you have to do it.
Okay.
We'll get into the training component related to force. I did the best I could to kind of quantify the hours and the amount of training we do. It's difficult to do because so much of our training is interrelated and overlapped. It's not training in a silo when you're talking about force. If I train you in CPR, I can give you an exact number of how many hours we train you in CPR and how often we have to refresh you. But when we talk about force, there's so many other things, such as tactics. Good tactics often prevent force. Communication skills. Good communication skills often prevent force. Crisis intervention training, recognizing people with mental illness, often will allow us to use other things than force. Those are not included. I will talk a little bit about those, but these are specific to use of force training. We'll begin in the regular basic course, also known as the Academy. We are one of 39 academies in the state of California. The minimum standards are governed by the Peace Officer Standard of Training, known as POST. They require 664 hours of training. Our academy is 880 hours. Of that 880 hours, 186 hours of it are force-specific related training. That includes classroom lecture, that covers policy, state law, and federal law. It includes firearm training, and it includes arrest and control, and defensive tactics, again, which also encompasses classroom time and time actually in the gym on the mat. Once our deputies graduate the academy, most often their first assignment is in custody. When they graduate from the Sheriff's Department regular basic course, they are not trained to a standard where they can work in a custody facility. Post views a regular basic course as preparation for a police officer to be successful in a field training program. There is a little bit of jail training in there, but it is specific to patrol. What we do then is we send our deputies heading to the jails for their first assignment to an additional 240 hours of training that gets them state certified to work in a jail facility. Of that 240 hours, 104 of those are force related, again, including classroom and time on the mat. Again, it's hard to quantify some of it. I did want to point out a training program that every single deputy and sergeant heading into the jails or working in the jails does go through. It's called de-escalation and verbal resolution training. Basically, it's crisis intervention training specific to the jails. It's a 32-hour course. Again, de-escalation and teaching people to communicate in the jail facility. Not specific to force, but does have a direct correlation to it.
Does that just relate, though, to the custody or jail situation, or does it relate to training for de-escalation for deputies on the patrol setting?
They learn skills there that are applicable everywhere. It's taught in the jail, specific to the jail facility, but the tools and lessons they are taught are applicable anywhere, because a lot of them are just communication skills. They're recognizing people in mental crisis.
You indicated that the de-escalation provision in the use of force policy, which applies both to patrol and to the jails, was put into the use of force policy a couple of years ago, not that long ago.
Yes, sir.
And I'm just wondering, have all of the deputies in the patrol setting that are working patrol received the de-escalation training? And if not, what percentage have?
You're jumping ahead of my presentation. We'll get to that in just a second. And we are working towards that. Once they graduate from the academy, every peace officer in the state of California is required to have 24 hours of continued professional training every 2-year cycle. If you are assigned to patrol, investigations, or traffic, 14 of those 24 hours have to be specific to what POST calls perishable skills. Those perishable skills include arrest and control, driver training, and tactical firearms and communications. What we do on the Sheriff's Department, even though it's only 14 of those 24 hours that are required, everybody in our patrol division, we give them the full 24 hours in those specific topics. We just launched LAUSD crisis intervention training. It's exactly the de-escalation training you were referring to, sir. Again, de-escalation tools, recognizing people in a mental crisis and ways to effectively communicate with them. The goal is to put every single deputy sheriff and every single sergeant through that training over the next several years. It is a new program. We began teaching it late last year. We do have funding to continue it, and our goal is to get everybody through the training in a 4 or 5 year period. On that topic, I'm really proud of where we have come from and as a profession and as a department related specifically to mental illness and crisis intervention training. I'll use myself as an example. By the time I had graduated the academy, I had gone to custody, worked my custody assignment, gone to patrol, worked my patrol assignment, and became a field training officer. I had received a total of 6 hours of mental illness training. You take somebody graduating from the Sheriff's Department Academy now, where we have almost triple the amount of crisis intervention training in the academy itself. That person now goes to custody division, where they get the 32 hours of the de-escalation and verbal resolution training. That person now comes to patrol, where they get the 32 hours crisis intervention training. That person goes to become a training officer. They go to our field training officer program, where they receive an additional 8 hours of training, and then as well as another 16-hour course. So you're taking somebody in my era who graduated and received 6, By the time somebody becomes a field training officer on the LA County Sheriff's Department now, they're receiving close to 100 hours of training and specialization. So really proud of where
We couldn't hear that, 100 hours.
close to 100 hours in this specialization. So that's it, essentially related to force specific. We do have other courses that have components in this. Many of them, such as our principled policing course that covers constitutional policing and implicit bias. Again, not directly force-related training, but has such a huge nexus to that. Again, our tactics and survival courses. Good tactics will also often put us in a position where we don't have to use force.
Yeah, I'm not sure, Commissioner Barrett, Commissioner Rubin.
Thank you, Captain. I really appreciate the presentation. I had a couple questions about the use of force definition, how that interacts with unholstering weapons. Does the department consider unholstering a weapon a use of force under 31010?
No, we do not.
Okay. So are there other specific policies that govern when and where a weapon can be unholstered?
It's done in our training. The unholstering a weapon is a tactical decision that's done through our tactics training that's begun in the academy and carried all the way through. It is not what we would consider a reportable use of force. If a deputy unholsters his weapon, it's not something he needs to report to a supervisor.
Meaning that the fact that a weapon was unholstered does not appear, isn't required to appear in any official report of the incident. Is that right?
It is not.
Okay. And to understand you correctly, so there's no written policy governing when a weapon can or cannot be unholstered. It's just governed by the sort of on-the-ground training at the academy and the other situations you've described.
Yes, sir, and the reasonableness of the situation.
Okay. And in your experience, is that the situation in other law enforcement agencies, or do you know of any written policies that govern unholstering of weapons?
There are very few departments out there that do mandate it as a reportable. I believe the San Francisco Police Department requires that, but there are very few in the state or in the nation that do.
Okay, thank you.
Commissioner Olson.
So, again, thanks for your presentation. I have some questions about the de-escalation training. One of the things that I'm been thinking a lot about as someone who teaches is pedagogy, but then also thinking about assessment and measuring effectiveness. So, you have 100 hours by the time someone reaches a specialization of de-escalation training. How do you measure the effectiveness? And I'm thinking about a video that's circulating now of a 76-year-old woman who was, looked like a Category 3 use of force because she refused to leave a ticketed area of Union Station. And in that case, it seemed to me that the situation escalated rapidly in a way that was unnecessary and seemingly unreasonable, at least at the first viewing of the video. And so I'm wondering, how do you assess whether or not all of these hours that the department is investing in de-escalation training, which I think is absolutely necessary, is actually working and is actually being implemented, on the custody side or on the patrol side? We
have a plan. This is very new training for us. Particularly as it comes to the patrol side. We began late last year. I think the effectiveness will bear out in the future as we see a decrease in use of force related to people with mental illness. We're in a mental illness crisis at that time. I think we will see the results of that. These trainings are not taught specifically by sworn members of the department. We partner them with mental health professionals. On the patrol side, where we have our crisis intervention training, we have 2 psychologists and 2 sergeants there that co-teach that course. At the end of every course, we do take a survey. We do an evaluation of the course, and we are, since it's so new, we are making constant adjustments based on that feedback. And we think that feedback is also a measure of how effective it is, how receptive our people, our deputies and our sergeants are to that training. And so far, it's been overwhelmingly receptive.
Just to follow up on that, will you do assessments thereafter? So it's one thing to do it once the people, deputies have taken a course and they're doing an assessment at the end of the course, but how will you measure it 6 months aside from decrease in use of force incidents? Is that the only measure? Is that the central measure, or will you try to find other ways to evaluate?
We actually had this conversation about a month ago with my instructors who brought up that exact topic. They want to come up with a way to have former students, after a period of time, give comments and feedback on that, about how effective it is, if they've been able to use the tools we've given them. So that is something we're considering. We are trying to figure out the best way to do that.
And then another question having to do with use of deadly force. How do you categorize taser use? So you specify use of handguns or firearms, but how do you categorize tasers? Because seemingly, to me, it seems to me that the tasers are deadly weapons, right? They can kill people when you use them, when you unholster them. So I'm wondering, do you have regulations specifically regarding tasers, or does that fall under the general objective reasonableness?
We have specific rules related to the use of a taser. The taser can only be used upon somebody that we classify as assaultive or high risk. We have a specific taser policy that precludes us from tasering somebody who is handcuffed, who's detained in the back seat of a radio car, or in a jail cell, unless some sort of circumstances arises where that would at that point become objectively reasonable. Taser deaths are very rare. The science on it is not exact as to the cause of death. The excited delirium theory, as well as other things, are being looked at. But right now, we do not classify the taser as deadly force, but can only be used against somebody who is assaulted, currently assaulting me, about to assault me, or a high-risk suspect.
Commissioner Giggins, Commissioner Rubin.
I have a couple of questions about the policy on shooting into vehicles. When was the last time that policy was updated? Do you know?
We updated that early last year, 2016.
Okay, and is the policy as it presently exists significantly different from what it had been previously?
It is worded much more strictly than the previous policy. The previous policy was very clear that we do not want to be shooting at moving vehicles or occupants in the vehicle. The policy was significantly shortened with a verbiage that is very clear. One of the reasons it's just typically not effective. We're not going to shoot that car and be able to stop that car. And it's very difficult to shoot the suspect in a car with a moving vehicle. It's just not an effective tactic.
Thank you.
Commissioner Giggins.
Yeah, back to the evaluation aspect of the training. Does anyone ever fail a training?
Yes, ma'am.
Never happens.
It depends at what level they're at. I can speak about the academy. They fail from day one. We've had people fail the course the day before graduation. Typically, in those occasions where they do fail the regular basic course, it depends on why they failed, whether we would allow them to come back. Any of those employees who failed for an integrity issue or a recruit code of conduct issue would never come back through our academy. If you came through the academy and you failed an academic component, or you got hurt or injured, that is somebody we would revisit and probably allow them to come back. The other courses, there is, depending on what the course is, there is pass or fail. There are tests given, and people do fail. In those instances, if they're already a deputy sheriff or a sworn member of the department, we remediate them. We're in contact with their unit of assignment, remediate them, and bring them back for more training.
Also, are there role plays, in the crisis intervention training, actual practice opportunities, or is it mostly looking at videos, didactic, and taking in information?
Both in the divert training and the patrol crisis intervention training, actual role playing is a big component of those. That's where we typically get our best feedback. Another thing we use is also video training, but it's the advanced video training where you're actually interacting with the screen, and the operator of that changes the outcome or changes the way the scenario progresses based on the way the student is handling that operation. That's a big component of those two.
Okay, Michelle, oh, excuse me.
One more.
Okay, and then I want to get on to Captain Wallem, just looking at the time.
I imagine you've heard the expression hands kill.
Yes.
So I've been hearing that a lot lately because I'm going to trainings. And it's almost as if many have editorialized, just what I said. Because it's almost, I've heard it so much during the training, and then yet part of the training is de-escalation. And, so my question is, are there people who look at, kind of go into the interior of the training of some of the conflicting messages, or could be possibly contradictory messages that could go on in the training, whereby it's really not as, it's not so clear when you wanted to bring in some new methodologies, when you have these old methodologies and mindsets that are prevalent?
That was the reason we co-teach the class. It's taught by SWORM members and mental health professionals. The SWORM members there to make sure that we're not giving that mixed message, make sure we're not going to compromise officer safety or our tactical advantage to go ahead and introduce a de-escalation tactic. That's the component of it that makes it such a great dynamic between the two teaching. Because de-escalation is fantastic. It's something we are training very hard on, but not at the expense of the safety of the deputy. Said a lot of words. Did I answer your question?
That's good, thank you.
Yes, so my question has to do with the relationship between disciplinary proceedings and the de-escalation policies. Have deputies been disciplined for failing to de-escalate a situation, or does that fall under the sort of unreasonable use of force? So the failure to de-escalate a situation is considered unreasonable force.
We do discipline for that, yes.
And I think this segues naturally into the next segment. Captain Wallem is going to speak on essentially use of force investigations. And if I could thank you, Captain Gage. Stick around, we may have more questions for you. But Captain Wallem.
Thank you. Good morning. Thank you also for inviting me here today and giving me this opportunity to speak to you about Internal Affairs Bureau and how we conduct investigations into misconduct as it relates to uses of force. So our department categorizes force, as you know and I've heard you speak this morning, into 3 different categories. Category 1, which is described above, force involves any of the following, and that's searching and handcuffing techniques resisted by a suspect, hobbling resisted by a suspect, control holds, or what we call come-alongs resisted by a suspect, takedowns and or the use of OC spray. Excuse me. I don't know how that helps. Okay. The use of OC spray or any of the OC that's in when we use pepper balls, anything of that nature. As long as the suspect is not struck by the pepper ball projectile and it only causes discomfort, not injury, it'll fall into the Category 1 category. Category 1 uses of force are traditionally handled and investigated at the unit level. I'm sorry, I don't think I did that either. Okay. So now I'm going to go for Category 2. So Category 2 is any of the following: any use of force that results in any type of identifiable injury, complaint of pain that medical evaluation determines is attributable to an identifiable injury, and any application of force other than those defined in Category 1 but does not rise to the level of a Category 3. And again, Category 2 uses of force are traditionally handled at the unit level. Now, Captain Gage talked about Category 3 uses of force, and it's once again, it's any shooting in which a shot was intentionally fired at a person by a department member, any type of shooting by a department member which results in a person being hit, force resulting in admittance to a hospital, any death following a use of force by any department member, all head strikes with impact weapons, kicks delivered from a standing position to an individual's head with a shod foot while the individual is lying on the ground or floor, knee strikes to an individual's head deliberately or recklessly causing their head to strike the ground, floor, or other hard fixed object. Deliberately or recklessly striking an individual's head against a hard fixed object, and skeletal fractures with the exception of minor fractures such as the nose, fingers, or toes caused by a department member. Additionally, all canine bites or any force which results in a response from the Internal Affairs Force Shooting Response Team. And all Category 3 force uses of force are investigated by Internal Affairs Bureau. The use of force review procedures, once again, Category 1 and 2, force incidents are reviewed by the individual units and forwarded to the respective divisions for final approval. Category 3, uses of force, again, are reviewed at the Executive Force Review Committee, and those are investigated by an IAB investigator. In cases of apparent misconduct or it appears that a department member failed to make proper notifications of the incident, the unit commander, where the force was used, shall decide if an administrative or criminal investigation is warranted by IAB or our criminal bureau, Internal Criminal Investigations Bureau. So once again, if a Category 1 or 2 use of force, which are handled at the unit level, meet the last bullet point there where the unit commander believes misconduct occurred, then Internal Affairs Bureau will conduct that misconduct investigation. And criminal investigations. Force incidents involving potential criminal misconduct by department members are investigated by our Internal Criminal Investigations Bureau. Upon completion of the criminal investigation, the case is submitted to the LA County DA's office, the Justice System Integrity Division, known as JSID. JSID reviews the circumstances of the case and makes a determination whether to file criminal charges or reject the case. If criminal charges are filed, the Internal Affairs Bureau monitors the case. Once the criminal case has concluded, an administrative investigation is initiated by the affected division chief and conducted by Internal Affairs Bureau. If criminal charges are not filed, an administrative investigation is initiated by the affected division chief and again conducted by Internal Affairs Bureau. So even if a criminal investigation at the conclusion, the DA's office does not file against our employee, we still do an administrative investigation and look into potential policy violations. So, Internal Affairs Bureau investigations. Force incidents involving potential policy violations by department members are investigated by Internal Affairs Bureau. An administrative investigation is conducted and submitted to the affected unit or division. Any discipline imposed is based upon the severity and evidence supporting the alleged violations. Discipline ranging from a written reprimand to 15-day suspension is decided by the unit commander and approved at the division level. Any discipline from 16 days suspension to discharge, including demotion, is decided by the division chief, and that's done through a process called the Executive Case Review Committee, which is comprised of our undersheriff and 2 assistant sheriffs. That's the panel that makes the decision, along with the division chief, proposing any type of discipline from 60 days to discharge, and again, including demotion. So, do you have any questions so far? Take them now.
And that is, what is the authorized number of investigators in the Internal Affairs Bureau? What's the authorized number? And how many are currently on board? I think all the investigators are at the sergeant level, so how many investigators are authorized, how many are on board?
All right, so that will be my next slide. So we are currently authorized and budgeted for 44 sergeant investigators, and currently there are 2 positions filled. Yes, and I'm sorry, it's right there. We are authorized for 44 sergeant investigators, and 32 of those 44 positions are currently filled.
And is that 44, even if you were actually up to 44 and you're not, you need to get sufficient enough, adequate number to do good, competent, and relatively rapid investigations of misconduct for a law enforcement organization the size of the Sheriff's Department?
Well, let me just say this about filling, if we were up to the 44 capacity. A few years ago, the CCJB made a recommendation that each Internal Affairs Bureau investigator have a caseload of average of about 7.1 cases. If we were to actually fulfill that recommendation, Internal Affairs Bureau would need 58 investigators with the current caseload. To go back to answer your question about the rapidness, thoroughness, and the accuracy of the investigations. Some of our investigations, they vary. We have some very complex investigations. One of our investigators just completed a case within statute time that she had to interview 60 persons. Now, and I want to just share this with you. When we're talking about interviewing any of our personnel, it requires them to obtain representation, and if the representation unions are backlogged, so will our interviews be backlogged. And so there are a lot of variables that come into play when we're talking about how rapidly can we produce the investigation. But what I will tell you is that even with the current caseload, which as of last week when we gave you guys the information, 13.7 cases per investigator, we do everything we absolutely can to stay on top of it, make sure we're providing enough detail and completing the case to give back to the division with as much time before statute as possible. And sometimes, we come right up to the last couple of weeks. And but again, those are the variables which will determine the outcome of how long.
But even under your own caseload analysis, the minimum staffing level would be 58 investigators and IAB, correct?
To meet the recommendations of the CCJ. Yes, that's correct.
Commissioner Thompson, Pastor Thompson.
How do you memorialize the incidents and how do we have access to category 1, 2, and 3? Just want to digress for a second. How do you chronicle those reports? Category 1, 2, 3, do you disperse that annually, quarterly, monthly? How will we access how many incidents of category 3 was there for the month of April? Or how many incidents of category 2? How do you do that? How do I do that? The department.
We have various ways of creating that, not only pulling the data out of the information system that we input it into, so we can pull reports for a bunch of different, let's say we wanted to know all category 3 uses of force that occurred at Men's Central Jail versus Twin Towers, or at Compton Station versus Crescenta Valley Station. We can produce those reports.
Is there a breakdown on that on a monthly basis, on a quarterly basis, or it's just to what?
Well, as far as internal goes, we're talking about the investigations that we're doing, and I don't want to say that there's a breakdown on a monthly basis or quarterly basis. We can certainly look at that, but when we're looking at our caseload, we don't have investigators who specialize, let's say, only in category 3 investigations. They have a wide variety of cases, and so the team lieutenants are monitoring every single case that every one of their investigators is assigned to. So I'm not sure that I understand.
Overall in the department, if we wanted to know whether it was Men's Central Jail or whether it was some other entity, but if we wanted to know how many category 3 incidents for from January to May, is there a sum total of that, or it has to be in an incremental basis?
No, I mean, we can retrieve it at any time. For internal affairs, I can speak only for internal affairs. We don't retrieve that data for a monthly basis or quarterly basis, or for purposes of just looking at it.
But it is accessible?
Yes, it is.
Oh, that's all.
Commissioner Olson?
So I have a question about the criminal investigation process.
That's okay. I can hear
Okay,
you.
so
I hear you, but people in the back can't, but I can hear you.
have a question about the criminal investigation process. So you mentioned that force, or in your slide, force incidents involving potential criminal misconduct by the department members are investigated by ICID. Who determines whether there is potential criminal misconduct?
Well, typically at the unit level, they are the first eyes on it. So if they even see a potential for it, they will vet it out. They will speak to the Internal Criminal Affairs unit commander. A conversation will take place, and if it requires, or if it, I don't want to say meets the criteria, if there is a potential, they will take the case on.
And this is, what's the relationship between ICID and Internal Affairs?
The relationship is that although our criminal bureau looks at potential crime-related misconduct, we do work hand-in-hand with them, because once any criminal investigation is completed, then the internal administrative investigation takes place, and that's how IA works in conjunction with criminal investigation.
And is the ICID, do they have similar staffing issues to Ivy, or are you aware?
I'm not, I couldn't speak to that. I don't know.
And maybe, again, this is outside the scope of your presentation, but do you know how many cases have been referred from ICID on an annual basis to the, I'm sorry, how many cases have been referred for prosecution, and how many cases have actually been prosecuted by the department, by the district attorney's office?
That I do not know. Yeah, that would be a stat from our ICID folks. But I can tell you that we're currently monitoring, and let me speak about monitors very quickly. What we call a monitor is an Internal Affairs Bureau investigator will be assigned to each case that is being looked at criminally, whether it's LAPD conducting a criminal investigation on one of our employees, or Baldwin Park, or the Sheriff's Department. There is an IAB sergeant assigned to monitor that case. So they will know when, say, the employee was convicted, or if there was filing, or if there was a plea, or anything like that. And currently, we had the numbers run today. We have 56 of those cases that Internal Affairs Bureau is monitoring that are being looked at criminally, either internally or by outside agencies.
We could probably get that information, and we'll ask staff to follow up on that. Before we move to the next agenda item, in view of the hour, I'd kind of like to move to it. But I just have one question, and that is that, the Commission is certainly going to be looking to hold the Sheriff Jim McDonald, responsible and accountable for the conduct of deputies within his department. Why doesn't the Sheriff have a role in discipline?
Why does the Sheriff have a role?
We're going to hold him accountable and responsible for misconduct by deputies. Why doesn't the Sheriff actually have a role in deciding what the discipline is?
Actually, he does, and to speak on that, I would have to turn that over to our undersheriff, but the Sheriff absolutely has a role in determining.
All right, and I'm going to defer we'll get an answer from the undersheriff, but not right this moment, because we're going to go to, we have public comment, excuse me. Go to public comment, on item 6 on the agenda, and let me call up Nick Napolitano, June Jackson, Audrey George, Kim McGill. Let's start with them. And I'm going to ask if you'd step forward and make your public comments. We are time challenged right now, so I'd like to have you come up here, and I'd like you to speak directly on the point of item 6, which is use of force policy, training, and internal investigations. Nick Napolitano is apparently not here. June Jackson.
Hello, my name is June Jackson, and I'm a previous employee of LA County Sheriff's Department. What I want to say is what the Sheriff's Department is supposed to be doing according to training and what they're doing is two different things. Our Sheriff's Department behaves like Gestapo, with no accountability and no prosecution. There's no proper investigations being done from the administrative level, the local level, or from Internal Affairs Bureau. And that's because our department heads are corrupt. Internal Affairs Bureau Director Karen Manis covered up my false arrest and imprisonment by sheriffs. Then she committed fraud against me and terminated my employment. There's no proper investigations. There's no oversight for sheriffs. That's the problem. There's no oversight. These meetings, it's just spinning your wheels because nobody's doing anything about the lives, people that are being harmed. The Sheriff's Department, again, cannot investigate themselves. Everything that the lady stood up here and said, it's about the Sheriff's Department having their hands in investigating their own people. They're incapable of doing that. And we repeatedly hear the same thing over and over again. When is something going to be done about this? You can't investigate yourself. You cover up your own misconduct and your own mistakes. And so, why are you guys here? Something needs to be done about that. If the Inspector General can't do anything about it, then we need somebody that can. People's lives are being affected. People are being killed. I've lost my job and all my benefits and everything due to the corrupt department heads. The policies, the procedures, the stuff that they stood up here and said, that doesn't mean anything. That's just words on paper. None of that stuff is being implemented. And we need change. We need department heads that are not corrupt in order for change to come about.
Thank you.
Hi, I had actually meant to come up and speak after Youth Justice Coalition and Dignity and Power Now. Can I shuffle back there?
You want to go after the next
Yeah.
item? Okay, we'll put you down for that. Kim McGill?
Microphone.
Microphone.
Is this better?
Yeah.
In your packets, we wanted to highlight that we also worked with families to create a suggested Bill of Rights, especially after use of force resulting in homicide. I wanted to highlight a couple of things. One is that we mentioned that there was an attempt to pass a law at the state level last year or actually earlier this year, to address police records and their lack of oversight and lack of transparency. I included that language because many of the commissioners asked me about that bill language, so that's included. But I also wanted to highlight that for LA County, this is a particularly serious issue, given the fact that LA County Sheriffs and LAPD compete each year over the past 30 years for number 1 and 2 spots on use of force resulting in homicide. We're not even close to other counties or cities, with now nearly 700 people, and we'll get the exact numbers to you shortly, people killed by law enforcement in LA County since 2000. There's a number of things that we found in those use of force allegations, but most notably, we couldn't get even information from LAPD or LA County Sheriffs as to which killings they were responsible for. We had to put in a public record request to the District Attorney's Office to get all the reports on the case. The other thing we gave to you today was the Memorandum of Understanding between the District Attorneys and all law enforcement agencies in LA County that states that they won't even begin their investigation until after the law enforcement investigation is exhausted. That means the District Attorneys are not stepping in to investigate except for rolling out to the scene. They don't do any other investigation until 6 months to a year and a half later. And every single report we got from them, in more than 300 reports, had the same paragraph, that their entire report was based on the analysis and the report that they got from the law enforcement agency. So there is no independent investigation. It speaks again to why this body is so important to have subpoena power, investigative authority, and have independent oversight of the sheriffs. Thank you.
My name is Shakur. YGC worked with families whose loved ones were killed by law enforcement in LA County, including county sheriffs, based on their experiences and our witnessing the treatment of families after shooting. We and victims' families created these rights. And y'all also have a copy of this, but just some of them. reach out immediately to family members after shooting without delay, and maintain regular and respectful communication with victims' families after each use of force. Ensure that no family member ever again hears from the media or a neighbor that their loved ones was killed. Demand and support independent investigations in all use of force incidents. Push the state attorney general to appoint a special prosecutor to investigate incidents nationwide. Demand that the district attorney's office start an immediate and independent investigation in law enforcement MOUs with the DA's office, establishing that the office won't begin their investigation until a law enforcement agency involved complies their investigation, often as much as 1 to 2 years later. 6. After all use of force resulting in serious injury or death, hold a community meeting within 2 weeks. This is open to family members, intervention workers, clergy, and or community-based organizations to air community concerns and answer questions. Throughout the process, act with humility. Do not make any comments that deflect responsibility away from the department, such as officers risk their lives every day, or many more people are killed by gang or community violence. Thank you.
All right, we have Michael. Mr. Khan. Now your time's up. I'm sure you.
Oh, that was funny. Oh, you're funny.
I'm going to say Michael YJC. We're asking for transparency. This commission was put because, as Kim just previously stated, I was given the chance to actually read through many of those reports, and it wasn't worded differently. It was cut and paste. So for any statement given by previous commenters or presenters on their diligent efforts of investigation, I can speak to them being false. I ask this commission if we are serious about being effective. When they stonewall you, make it public. Thank you.
Thank you. Mr. Khan?
Good afternoon again. So I just wanted to raise a few things as we were speaking about it. I wanted to thank Commissioner Ocean for bringing up the issue of tasers, because it's an average of 45 to 48 deaths a year around the country as a result of the use of tasers. So I think when we talk about use of force, a lot of times it gets lost into the bullet hitting the body. But I think one piece that I do want to lift is the trauma as the use of force, that many times the conversation stays between the victim and the perpetrator of force, and in this case law enforcement as the use of force, but the human impact extends beyond the individual himself. And I'm reminded of the case of a young man, Usman Chaudhry, who was severely autistic, was murdered by the LAPD, and the family was not even informed. The family didn't even know about it for at least a week. And particularly it was very traumatic because it was a Muslim family, and so the mother and the parents really were extremely traumatized because the burial rituals, the way that the community and the family wanted to, as per their tradition, never happened. So I think the issue of family notification becomes really critical. Another case of Waukesha Wilson, who died in custody, and yet at the same time, this happened last year, and the mother and the family was never notified. I mean, she was supposed to call the family calls the place, and they're like, well, we don't know where she is, she was in custody. And 3 days later, the mother gets a call from the coroner's office. So I think the issue here is that how we notify the family, and I know these issues have been raised very eloquently by Tawhida and some of the other youth from YJC. So I would just really very strongly suggest that as we are talking about policy of the use of force, not to forget the human trauma and not to forget the impact on the family and the community as well.
Thank you. Mr. Brizzetti, I'm going to get to you, but we've got to go to the next panel.
That's no problem,
Okay,
sir, no problem.
In the interest of time. So we're going to we have the next panel, which is going to be discussing the Sheriff's Office complaints process. We've got the briefing from the Sheriff's Office, I think, a couple of meetings ago. And we have the ACLU, Dignity and Power Now, and Youth Justice Coalition, all of which are going to be addressing their perceptions of the complaints process and maybe some recommendations as to how it could be improved. I'm going to start with Esther Lim of the ACLU, if you can step forward, and then we will follow that by, we have two spokespeople for the Dignity and Power Now Coalition, and Michelle Infante, and then Kim McGill will speak on behalf of the Youth Justice Coalition.
Doing really good work, Kim.
It's been allotted 10 minutes, so I'm going to have to
Get into the arts.
do your very best.
Are you familiar with the arts thing with the jails? Well, I'm going to teach you how to know violence.
Good morning or afternoon. Thank you, Commission, for allowing us to have a space to share concerns about the Sheriff's Department.
Kim.